What is monopolization under Section 2 of the Sherman Act? Generally, it entails acquiring monopoly power in a given market by means that is anti-competitive, by means that other than pure competition. So pure competition would be a superior product, superior strategy, operational efficiency, etc. Any competitive means would be one of any laundry list of types of activities that could give an unfair advantage. One of those being an exclusionary act. Okay. Exclusionary acts include something like closing off resources to others by buying up all the resources available, exclusive sales agreements, limiting the supply chain that way where it forecloses other entrants into the market, certain tying relationships where you tie the sale of one product to the purchase of another. So it effectively shuts out others in the market for that tied or related good. Forced acquisitions, that is, you seek to put others out of business unless they deal exclusively with you, or you force them into a sale or to merge or with you as part of your coercion towards your dealing arrangement. And then mandatory leasing arrangements where you force individuals into long-term leases in situations to, again, to exclude others or foreclose a channel of supply in that situation. So all of these are exclusionary acts, and they fall under, again, the definition of acts that would constitute monopolization. There are certain other acts that are included there as well, such as refusing to deal with others. Now, generally, as we previously said, competitors are not required to deal together, but when it effectively pushes others out of the market, when there is the anti-competitive effect on the market realized from these refusals to deal with others, and that can actually be vertical as well as horizontal. Again, it's going to be weighed under the rule of reason. The same as with the exclusionary acts as to whether it has an anti-competitive effect and what the pro-competitive justifications are. So again, this is going to be one of those floating standards. And then you have the predatory pricing situation. Now, this is one of those situations that can be per se legal, that you're pricing below your marginal cost, and that has the intent behind it to push a competitor out of the market in that way and to concentrate monopoly power in the seller. But to a lesser extent, if there is some pro-competitive justification, this is where you might get the truncated or quick look rule of reason and potentially be able to put forward some pro-competitive justifications for the court to weigh the activity to determine whether it should be deemed monopolistic behavior and thereby a violation of Section 2.